Honor, today is the date and time set for the probable cause conference. However, I have spoken with Mr. Edwards, and there appears to be a breakdown in communication between Mr. Edwards and our office. He does not believe that we are fighting in his best interest, and we are asking that our office be withdrawn because I do not believe that this breakdown is something that's going to be. So we're asking to have our office withdrawn and new counsel appointed.
Mr. Edwards, what's the problem?
Beg your pardon?
What's the problem?
I believe the attorney can answer it better than I can legally.
Can what?
He can answer that better than I can.
Are you asking to have counsel removed?
Yes,
Why?
it's been a breakdown in our communication.
What's that mean?
We disagree with things we can't see eye to eye. I have yet to go over with him the discovery, everything that this case is about.
I don't know what that means. You haven't had a chance to go over it with him?
He hasn't went over it with me.
Pardon?
He hasn't went over that with me. Any of my requests is, a matter of fact, he had told me that I could get my, transcript or the paperwork, I don't know the legal terms to put it in, today.
That you could get your discovery today? Is that? You're not going to go through trying to pick attorneys, Mr. Edwards. I think we went through this before. Yeah.
I'm so sorry. Ms. Hightower.
I'm going to have to see a motion. I don't understand what this is about. We went through this the last time. I told him to listen to you. You didn't want to listen to him?
I did listen to it.
And so what's the problem?
That's why I said that he can explain it better, because like you said, there's a breakdown. You can't understand it from me, and so maybe he can tell you in the terms that you'll understand.
Mr. Brown, without
Revealing,
right, yes. What's the problem?
Your Honor, I've had several visits with my client, and the upshot is he has made it clear that he does not believe that our office is working in his best interest. He does not believe that we are trying to help him in this case.
Right. My question is, in your opinion, is there a valid reason for his insistence in not wanting your office? I don't need to know the specifics. I'm just asking your opinion, because it just sounds to me like he just wants to complain.
Well, of course, Your Honor, from my point of view, there's not a valid basis for what he's saying, but there is the fact that there is a breakdown in communication. He simply will not take my guidance or my advice, and whether or not it's based on anything that's substantive or real, the fact is, if he's not taking my guidance, not listening to me, and not hearing what I'm having to say, then that constitutes a breakdown in communication that I can't overcome.
So he's making it impossible for you to work. Well, you don't have to say that. That's my conclusion.
I got very much.
All right. Well, we'll have to try to find an attorney then. So take him back, and then we'll bring him back out at some point and figure that out. I need the formal motion before me, so it's got to get here.
All right. Thank you, Your Honor. We can do that.
Or to pass that one here. I now have a written motion before me allowing the public defender to withdraw. I'll be honest with you, I don't necessarily see a need to do that. I think the defendant's kind of picking and choosing his attorney. I'm going to allow it this time. Mr. Killowald's been appointed to represent him.
All right. Thank you, Your Honor.
All right. Esteban.
Yes, it's a motion for bond reduction. I think he says he doesn't have a prior record except for one OUIL, and that he came here in compliance with the court order,
After drinking. Yeah,
he had been,
which he's not supposed to be doing.
right.
So why would I lower his bond?
I think there's a chance that he'll prevail on the underlying case, the domestic violence. And I think lastly, having been in here, is, look, the man's in shackles. For a person who's really not a habitual or a regular, he's in handcuffs and shackles. I think he learned.
That's the way we transport.
I know, but I think he learned his lesson.
Yeah, yeah.
You want to speak? Speak for yourself. Speak.
Yes, Your Honor. I learned my lesson. Then plus, if I want to get out so I can try to take care of my business at home, and I could, if it could, I would pay $500 to get out. But that's
He's saying he's requesting 5,000, 10%. That's what he's trying to add. Thank you.
Go ahead.
That's all I have.
Your Honor, I did have an opportunity to discuss the bond violation with him. He did appear remorseful and understood when I explained the violation. He did admit to the violation and would have no objection to being placed on a sober link or a scram tether of any kind to ensure he maintains his rights.
Well, I agree with that. And in addition, I'm sorry, I forgot one fact. He has family support. I've spoken with his sister since I've been here.
Clarify one thing for the record. He does have priors. He has a DV from 2010 as well as multiple OWIs.
Well, I heard of one.
Well, the one from 2003 is the second, so you don't get that stuff first.
Oh, I didn't know nothing about that.
I don't have anything to add. He said he did.
Good. Motion for bond reduction on both matters is denied. Bond will continue. Thank you. Excuse me? Really? Yeah. Ow. Go back out. Bye. Thank you. Go ahead, Mr. Vincent. No, I'm good. Go. Anybody else got any names they want to yell out? No? Good. Go ahead, Mr. Vincent. You can't make it. Go ahead.
Your Honor, my name is Alex Parks. I'm requesting to practice pursuant to.
Tell your client to take his hands out of his pockets, please. Go ahead.
I'm requesting to practice pursuant to MCR 8.120 under the supervision of Mr. Gaddy.
Mr. Gaddy explained to you, you don't yell names in the courtroom.
He did.
That will never happen again,
It will
correct?
not.
Thank you. Permission to practice is granted.
Yes, Your Honor, that's my fault.
No, it's not. I know you would have taught her better. I've known you a long time, Mr. Gaddy. It's all her responsibility. Go ahead.
Mr. Button, please state your name.
Daniel Button.
Thank you.
Your Honor, we're asking for an adjournment in this matter for time to reach a resolution.
Probable cause conference without objection, June 27, 2024, 9 a.m. Bond continued.
Thank you.
Thank you.
Nicholas Kozitza.
Who?
Nicholas Kozitza. Kozitza.
How's that spelled?
Kozitza.
Oh, proper spelling. Okay, go ahead. Where are you from? Never mind. Go ahead with your spiel.
Nicholas Kozitza. I'm requesting permission to practice pursuant to Michigan Court Rule 8.1.
Are you reading that?
Yes, I am.
You couldn't memorize it?
I have it memorized.
You do?
Yes.
All right, then look at me when you're saying it.
Nicholas Kozitza, requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision.
Whoa. Whoa. No, you gotta start again. That's not how our court rules are set.
Oh, Michigan Court Rule 8.120
Thank you.
under the supervision of Assistant Public Defender Tortia Feaster, representing Mr. Michael White.
Where are you from?
I am from originally California.
Oh, that explains it. All right, where are you in school?
MSU Law, Michigan State.
Oh, a Spartan.
So
Did you know that?
I did.
You did? And you still let him get up here in front of me?
I think we said, we tested on the fire.
I'm a terrapin. I don't really like Spartans much.
I won.
All right, permission to practice is granted. This poor gentleman's been waiting.
thank you. Mr. White, please state your name.
Michael White.
Thank you, sir.
We've spoken with Mr. White and we'd like to set this for preliminary examination.
All right, is all discovery complete?
Yes, Your Honor.
Yes.
All right. And would the people have their witnesses available on the 18th?
We'll do our best.
Preliminary examination in person will be June 18th, 2024, 9 a.m. That is before Judge Stalvo. All right. We'll continue. Thank you. Thank you, sir. It's funny. It's funny. So who's that next to him? I know. So he goes back there to sit down. She's like, oh, good job. She didn't know. All right. Anyway. And no, that was great encouragement. And he like nodded, but yeah, I know. All right. Anyway. That's it for me.
Yes.
All right. Court's going to stand in recess. We'll come back at noon. Thank you.
This chaotic day in Judge Simpson's courtroom kicks off with tension, not from a defendant's case, but from Mr. Edwards trying to fire his own attorney. Again, his public defender tells the judge there's been a total breakdown in communication, and that Mr. Edwards refuses to listen to any advice. But when the judge presses for details, Edwards can't explain anything clearly. He insists he hasn't gone over discovery, and we just don't see eye to eye, leaving Judge Simpson visibly frustrated as she reminds him this issue happened before. The attorney finally spells it out. Mr. Edwards simply won't cooperate at all. Despite not liking it, Judge Simpson grants the withdrawal and appoints new counsel, warning she doesn't want defendants picking and choosing lawyers, but the drama isn't over. Next comes an emotional bond reduction request. The defense argues Edwards learned his lesson, the prosecutor disagrees, and the defendant pleads directly. I just want to get out to take care of my business at home. But when the judge learns he violated bond by drinking and has prior DV charges, she shuts it down immediately. Bond reduction denied just when the courtroom settles. Comedy strikes, a nervous law student pops up to request permission to practice, and Judge Simpson roasts him instantly for yelling names in court and reading his request off paper. Then another law student steps up and accidentally has to repeat his entire script. Judge Simpson can't believe it. No, you only need to do that once per session. The courtroom bursts into laughter as she jokes about his school, his delivery, and his whole California thing before finally granting permission. The day ends with a few routine hearings, light teasing, and the judge shaking her head at the unexpected chaos of the morning, a perfect mix of drama, frustration, comedy, and classic Judge Simpson energy, all packed into one unforgettable hearing, *. Like, subscribe and hit the for more real courtroom drama.